Question we get is this: do I need a will here in Georgia? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia, and I'll answer that question in today's video. So the question of the day is this: do I need a will in Georgia? And the answer may surprise you. It's not really a simple, straightforward yes or no. It's really it depends. And what it depends on is what you're comfortable with, what your wishes are, and it may come down to your definition of the word need as well. Let me explain. So first, if you have a will, what you have is a legal document that's going to set forth your wishes on how you want your assets distributed after your death, after all of your bills and debts are paid, and it's going to identify who you want to be in charge of that process. We call that person the executor. The will also sets forth your wishes on how you want your remains handled. Do you want your body buried or cremated or donated to medical science or etc.? If you have minor-aged children, the will is also going to specify who should look after them, who should care for them as they grow and mature into adulthood. That's what a will does. Now, if it's important to you that your wishes about these things are known and followed, that the people you select are put in charge of the process to settle your estate, to look after and raise your minor-aged children, then I think the answer to the question of the day, do I need a will, is clearly yes. But on the other hand, if you really have no care at all about these things, if you don't care how your assets are distributed once you pass, if you don't care about who's going to handle that process, or maybe trying to avoid family conflict and disharmony because a plan wasn't laid out, then maybe you don't need a will. And if you have minor-aged children and you really have no desire to be in control of selecting the right, responsible people to raise them and look after them, then perhaps the answer for you of our question of the day of do I need a will is no. But I'll tell you, I haven't really met anybody that falls into that last camp. But if that's you by chance, I think before you answer the question, do I need a will, you need to understand a few things about what's going to happen later to make sure you're comfortable with the decision you reach. Because you see, if you don't create your own will during your life, you actually wind up with a will substitute plan that was created for you by the state of Georgia, by the legislature. It's not really called a will, it's called Georgia's Laws of Intestate Succession. When you die without a will, you're said to have died intestate. And every state, including Georgia, has a set of laws called the Laws of Intestacy. And so if you die without a will, you die intestate, then these laws of intestate succession, the laws of intestacy, are going to control what's going to happen. Those are the laws that the probate courts in Georgia will follow. A lot of people have a misunderstanding about what those laws of intestate succession say. For example, I've had people argue with me that if they're married with kids, when they die, if they die without a will, then their spouse will inherit everything. Everything goes to the surviving spouse. That's simply not true here in Georgia. If you die without a will, you die intestate, and you're married with children, your surviving spouse and your children will equally share your probate estate, provided that the spouse gets no less than 1/3 of the assets. If that's not your plan, if that's not how you want things done, you have to do your own planning. Because when you don't do your own planning and you die intestate, Georgia's laws of intestate succession control. Maybe you had something else in mind, but because you did not prepare a will, because you did not do any estate planning, those wishes are not going to be followed. And if you don't have a spouse or children to inherit, the state is then going to look at your next closest living relatives. Perhaps it's going to be grandchildren or great-grandchildren, other descendants. If none, maybe we'll look to parents and then fan out to siblings and aunts and uncles and nieces and nephews and first cousins and second cousins and so on and so forth. And what will happen is the court will pull out what's called a table of consanguinity that outlines those in the closest degree of kinship to you, and those people would be the ones to inherit your estate. Now, because you didn't have a will, you also don't get to determine how things are going to be divided, but also you don't get to determine who's going to be in charge of that process. We call the executor of an intestate estate the administrator. So your family may have difficulty in agreeing on who should be the administrator of your probate estate, and that could lead to a conflict that could lead to a lengthy and costly court battle over this. Generally speaking, I think that for the vast majority of people I've met, the answer to the question of whether they need a will is a resounding yes. And that is really because of the 5 main benefits that you get from doing your own will, doing your own estate planning. The first benefit is control over asset distribution. That's one of the primary benefits of having a will. It allows you to control how your assets will be distributed after your death, to whom they're going. You can specify what friends and family members, charities, and other organizations should receive your assets and in what proportion. This, of course, ensures your wishes are known and will be followed. The second benefit is appointing an executor, somebody who's going to be in charge of the process. Your executor will get appointed by the court. They'll marshal together your assets, pay off your bills, and then distribute the assets in accordance with your will. The third benefit comes into play for those who have minor-aged children. Here, you get to designate a guardian for your child or children if there's no other natural living parent alive who has the capability of raising them. And so you can pick the right people that have the responsibility, that share your values and are willing to look after your kids and help raise them. In addition, if you're leaving assets behind for your children, you can designate a trustee to manage those assets on their behalf. And then based on your plan for when and how to release it to them, once the children are grown and mature and responsible, then the trustee can turn those assets over. The fourth big benefit of doing a will, having your own estate plan, is to help avoid or reduce conflicts. When you die intestate without a will, your assets, of course, as we said, will be distributed by Georgia's intestacy laws, which that may not be in accordance with your wishes or with the family's wishes, and that may bring about some conflict there that will be battled out in the probate court, including conflict about who should be in the role of the administrator. And then I think the fifth benefit is saving some time, energy, and money. When you have a will in place, you can help make the probate process easier and more efficient. That can reduce the time involved in probate, reduce other costs associated with that proceeding, and make it more streamlined and more efficient, as opposed to somebody dying intestate where there may be more battles along the way through that process. So overall, having a will in Georgia, of course, can provide you with peace of mind that your wishes are known and are going to be followed, but it can also provide those additional benefits that we just discussed. It's always a good idea to consult with a qualified estate planning attorney to discuss your individual situation and your goals and wishes to determine whether a will or some other planning tools may be most appropriate for your situation. If you'd like more information on estate planning here in Georgia, I invite you to visit us online at peachstatewills.com. Click on Free Info at the top of the page, then select Estate Planning Resources. And there you can get a copy for free, no strings attached, of our Guide to Estate Planning in Georgia. We'll also give you our bonus report, 10 Estate Planning Mistakes to Avoid. Or if you're ready to go ahead and get started and sit down with one of our experienced planning attorneys, give us a call. We'd love to talk to you and see if we might be a good fit to work together. Our number is 678-344-5342. Remember, estate planning doesn't have to be hard, and we can help.